So who wants to think and talk about death other than Woody Allen and a few of my relatives at family picnics? Death is not exactly the most comfortable topic for most people to ponder, but if we don't assume the responsibility of making choices about the kind of medical care we want at the end of our lives, who ends up taking on the burden? In this program, we're going to learn about advanced directives, also known as living wills. Also, we'll learn about POLST, or Practitioner Orders for Life-Sustaining Treatment, and other issues that will help us hopefully make more informed decisions about the most inevitable event in our lives. I'm Mary Lynn Chiave, and welcome to Pro Se Nation, Understand the Law for Oneself. Joining me today is Terri Roth Reicher, an attorney and mediator based in Passaic County, New Jersey. Ms. Reicher earned an advanced law degree from Seton Hall University School of Law, where she was a member of the first LLM class in health and hospital law. She writes and lectures frequently on issues in bioethics and serves as a bioethics attorney for Chilton Hospital, a member of the Atlantic Health System. She is an adjunct professor of law at William Patterson University and a leader in the alternate dispute resolution community, with a private practice specializing in commercial disputes and elder mediations. She is the 2016 recipient of the J. Dell Award for Professionalism, Ethics, and Service to the ADR community. Is it getting easier for people to talk about these issues?
Statistically, if you read in the literature, they'll tell you that maybe 1 out of 5 people have living wills, advanced directives. But when I lecture throughout the community in many different venues, and quite often it's often in senior centers, many more seniors have them than the 1 in 5. I think what has happened is, let me give you a little historical perspective. There are the trio or the trilogy of famous cases. We have the Karen Ann Quinlan case, which was right here in New Jersey, which is considered the first right to die case. After the Quinlan case, there was a U.S. Supreme Court case called Cruzan, which is really the most instrumental related to this topic. And then there's a follow-up case, Terri Schiavo.
Yes.
And you know that it was in the papers, as you said. They've been made for TV movies. So people are much more aware of these things. Cruzan was really the case that brought us to advanced directives. Cruzan was a U.S. Supreme Court case, and in Cruzan, the court announced that everyone has the right to express what their wishes would be in a clear and convincing way. They allowed that right to be taken over by the states, and every state had the right to decide what would be clear and convincing evidence in their state. Because New Jersey has such a strong history of being involved in right-to-die cases with the Karen and Quinlan case, we were in fact the 49th out of 50th state to have living will legislation, because our courts were so much more sophisticated that the legislature didn't really feel the need to jump in, where in other states it was somewhat different. But now all the states have what's called advanced directive legislation, or advanced directive statutory guidelines in some manner, shape, or form. And New Jersey's is fairly standard.
So just to kind of define our terms, if we can begin with what is an advanced directive, because I think a lot of people have heard about it as a living will. They tend to, when they hear the two, think that they're different. So advanced directives and living wills, and then I know you're also going to talk about POLST.
So let's start with the term living will, because that's the most commonly used.
Sure.
Okay. The biggest problem is that in this nomenclature, people have called it living wills. People, non-lawyers, hear the word will, and you immediately think of your money.
Right.
And living will has to do with your healthcare choices, not your money choices.
Right.
So that is where most of the confusion comes from. But now I'll get a little technical on you, but not very much. Advance directive is the technical term.
Right.
Within an advance directive, there's technically two components. One is the instruction directive, or the living will,
Right.
which basically says, yes, I want to be intubated, no, I want a feeding tube, all those things
Right.
those medical concerns that you've dealt with. The second component of an advance directive is in fact the proxy directive. And the proxy directive is the place in which you pick your representative, you're picking your spokesperson, and simply pick your person. So think of it as your pick your person part of the document.
Okay.
Technically, you can have one or the other. I very much recommend both, but with a caveat. And when I say with a caveat, I shared with you before the program a couple of simple living wills. So this might be a good time to share with the audience where you can get them. So
Right.
that living wills are very easily obtained. You can get them from any of the hospitals. So if there's a hospital you tend to use, they will have one. You can, any of the clergy have them, because all the religions tend to have ones that are in keeping with their religious philosophies. You can go to LegalZoom, you can go on the internet. They are ubiquitous. There's no one standard form. I'm
glad you said that, because I'm trying to get them as a sponsor. Did you hear that? No. So they're readily accessible.
They're readily accessible, and they're readily accessible without a fee.
Okay.
And the advance directive arguably does not need an attorney to complete it.
Okay.
But this is the rub a little bit. What happens often is that a family will go to an estate planning lawyer to take care of their stuff, as they would say. And they're very busily worrying about the tax aspects of and the way they give it and who they give their assets to. And then the estate planning lawyer, of which I was one for many, many years, would say, well, in order for the package to be complete, I need you to give you an advance directive. And it's sort of thrown in as the Rodney Dangerfield of estate planning. And what happens is, it's not uncommon that a lawyer, when they're doing it for you, will in fact give you a fairly complicated advance directive. My recommendation is, I'm not saying
Is that because lawyers always make things complicated?
and
More
we are
complicated?
partial to words. My recommendation is, although an advance directive is a legal document, it's a legal document that only jumps into being, so to speak, at the bedside if someone can no longer speak for themselves. So if you want to increase the odds of your living will being followed to the extent that you executed it, you're in a much better position to, one, keep a simple one, because you're asking the doctors and nurses to interpret it at the bedside in a crisis. And you're much better off, arguably, using the form that the hospital has generated, because it's the form they know what's in it. They know how to in fact apply it. So from that perspective, there's no reason for anyone not to have a living will. So a living will and advance directive really can be completed by any competent person 18 years old and older. Typically what happens is, when you go into a hospital in a non-crisis situation, they will say to you, do you have an advance directive? Now, what's happening currently is that no matter what you're going to the hospital for, they say to you, do you have an advance directive? And it makes people very nervous. I'm only coming in for an MRI. Do you expect that I'm not going to survive this? Well, that comes from rules that originally came into play, that if the hospital participates in Medicare, they're obligated to educate their community. What has been interpreted as an educational component for the community is to ask whether you have one. Then the standard question, the follow-up question, if you say yes, they check the box, and then they say, do you have it? And if you came in for an MRI, obviously don't have it with you. And then if you say, no, I don't have one, then their next follow-up question is supposed to be, would you like some assistance in filling one out? So that they will either bring someone from, they will make available to you forms, the social workers, the clergy, different people within the hospital can help you fill it out. But going back to your scenario, what happens is the odds are that person may have their license and credit cards on them, but the odds are they don't have their living will on them.
Right.
When you contact EMT or any emergency services, the emphasis is on E for emergency.
Right.
So by calling them, you are obligating them to provide you with whatever emergency services they can. Once you are stabilized, and if someone in your family is aware that you have a living will,
Right.
and they can access that living will, then they will bring it, and then your living will ultimately be followed. So years ago, way back in the 70s, when the technology was improving such that it was ahead of the law,
Right.
the old adage was, once you're on the machine, you never come off the machine. That's no longer true. These living wills provide for the safe withdrawal if it is
Right.
appropriate.
Right.
So in your emergency scenario, you would be stabilized, you would be treated emergently, and then your family would produce the advance directive. But that brings me, if it's okay, that brings me to an important part
Sure.
of this.
Sure.
The living will is intended to be a tool. A tool to get the conversation going, to have the communication with your family members. If you just fill out the form and stick it in the safety deposit box, you really haven't accomplished what the living will is intended
Right.
to do. The other misconception, because
Unless you carry it with you when you're driving. I mean, unless it becomes part of your license or what's in your wallet. Or
there are states
Yeah.
and there are people that are committed to this,
Right.
who will register their living will with the national registry, and they will have a card. That is the very rare person currently.
Okay.
The other thing that may happen, and again, this is in the future, we now have proliferation of electronic medical records.
Right.
So years ago, they would say, once you gave us a living will a year ago, oh, it got lost in your records. Theoretically, your living will should be able to be accessed much more easily. But again, this is in the infancy. The average person does not drive around with their living will. However, the misconception in this field is when you have a testamentary will, and when I say testamentary will, I mean the will that divides your
Deals
property.
with your stuff.
Your
Yeah.
stuff. The lawyer will say, we have one signed copy, you have to put it in a fireproof place, put it in either the lawyer's office or in a safety deposit, and it really needs to be safeguarded. With your advance directive, you arguably want to complete at least 6 copies. Right. You want to have one for yourself, one for your proxy, one for your alternate proxy, one for your doctor, a couple of extras. So people will say, oh, I have this estate package, I'm going to put it all in the safety deposit box, and then your advance directive isn't accessible.
Exactly.
So that's another thing that people need to distinguish this legal document from the testamentary wills and trusts that they may be completing.
Now, the other thing you brought up, the aspect of medical technology advancing so rapidly, and God help us, maybe one day intubation is going to be done differently, where it's not something, someone who fears having a tube down their throat. It's going to be, who knows, done differently. So it seems as though you need to update your advance directive probably. How often?
Not really.
No.
Yes, you do, but not for that reason.
Okay.
Okay. You really asked me 2 questions.
Okay.
Okay. So the first question.
I usually ask 10 questions at a time, so only 2.
So only 2.
Not bad.
So if I keep mentioning that the forms are ubiquitous, so I happen to share with you
Right.
an Atlantic Health form.
Right.
So if you notice the form, when it comes to the instruction directive, is very, very simple.
Okay.
The form arguably says, I want all medical treatment, I want no medical treatment, or I want this very limited amount, and they give you a few choices, and then there's a line where you can fill in. My opinion, and I've been dealing with this subject since the field has evolved, is that the most important thing for you to fill out is the proxy, meaning pick the right person, make sure there is an alternate, have the discussion with them so that they know what you really want, and keep your preferences philosophical and not really medical, or your form will never be current.
Oh,
okay. In terms of keeping up. So that deals with the aspect of keeping it really simple. Now, this is another problem with this area. Okay. If you go to a lawyer's office and do a testamentary will, and you actually read the will that they draft for you, the first line invariably in every will say, I hereby revoke what my previous wills were. Okay? The assumption is that during people's lifetime, they may have done a few wills. If you examine the form that I gave you for an advance directive, or the other ones online or in the other resources, I have never seen, unless it's a custom one, that a lawyer who has taken some care, never says, I hereby revoke my previous living wills. So my advice to someone, assuming they don't have a custom living will where the lawyer has in fact said, I hereby revoke my previous living will on dated such and such, my advice is to take the living will, which is just a few pages long, and every few years, if you're comfortable with it, if your proxy is still the person you want to be your proxy, and your alternate is still, and their phone numbers and addresses are still accurate, just I recommend on the bottom of the end of the form, reviewed, and then give the current date. So it indicates, even though it might have been completed 10 years ago, it's still current 2 years old. That's my best recommendation at this point, because I have not seen forms at this point that say, I hereby revoke my previous living living wills. So
I do want to get to, I know we're, I don't want to say we're running out of time, but I definitely want to get to POLST.
Sure.
And if you could give the definition of that. Okay, we have 5 minutes.
Okay.
How'd that happen? Okay, so POLST actually stands for, and you corrected me, I thought it was physician, it's actually Practitioner's Orders for Life-Sustaining Treatment.
In New Jersey,
you got 5 minutes.
It's practitioner's orders for life-sustaining. In some other states, it's physician. And in New Jersey, it is not considered, it's not a legal document, it is a medical order. So because it's a medical order, it can only be completed by a medical person. And the acceptable medical persons in New Jersey, a licensed physician, a DO, or a nurse practitioner. So those are the people that can complete it with your input. Now, the POLST is a very, very limited document, where the advance directive was for anyone over 18. The POLST has a very limited, specific audience, so it can supplement the advance directive. The POLST is for someone who is terminally ill, seriously ill, very, very frail and aged, and the test that the physicians typically use to determine whether it's appropriate to recommend a POLST for this person is the practitioner would not be surprised if the person were to die within the year. The other thing is, where I kept saying the forms are ubiquitous for advance directives, for POLST, there is one statutory form. It is recommended that it come on a bright green paper. And the very interesting thing they do at the beginning, besides they do go into more detail in terms of to what extent do you want feeding tube, nutrition, resuscitation. The very beginning of the form has what's called the goals of care. And goals of care really humanizes the form, which basically is the physician's time to talk to you, or the nurse practitioner's time to talk to you, to say, you most likely have a very limited time period remaining to live. what do you want? What do you seek? What would you like to happen? And it's not uncommon for someone to say, I really like to live long enough to see my granddaughter married, my grandson's graduation. And that's the appropriate place on the document. Technically, that's not a medical order, but it was felt that in order to have a meaningful discussion, you needed to start it with that and with that question.
Okay. Why wouldn't the advance directive cover this?
POLST is meant to in fact be transportable from all different venues.
Okay.
So arguably someone in their very last days, not uncommonly, are bounced around from nursing home, hospital, hospice, home, and by having this very distinctive green form that's identifiable by the EMTs, that can be transported from place to place, it is much more spot on. And now it doesn't mean that you can't have an advance directive, but this really deals with the reality of someone's
So it sounds like it's much more specific, and it's much more. I mean, you're making these decisions when death is perhaps more imminent, as opposed to a more abstract idea.
Exactly.
Okay.
Exactly.
Okay.
How do you pick your proxy?
Right.
Okay. People will often say, well, I have to pick my eldest. That's assuming you're completing an advance directive. I don't recommend that. What I recommend is, first of all, people assume it's their spouse if they have a spouse.
Right.
If your spouse does not share your same philosophy on end of life, you may be asking the spouse to do something that they are not comfortable doing.
Right.
It's much better to have the conversation and say, I don't want to put you in that tough position. Perhaps we'll ask one of the children.
Right.
The other guideline is, if you have anyone in the family who is involved in the medical field, is comfortable being in a hospital setting, they are usually much better proxy than the accountant child, for instance. So often when I'm counseling people, when I was in private practice and doing the testimony wills and the living wills, what I would say is, okay, your accountant child will be a fabulous executor for the estate, but perhaps your nurse child will really be the one that you want to have as your proxy. Now, going back to the question, if the family doesn't agree,
right,
or if it's not a Donna Reed family, and then there's something that the hospitals have, which is called a bioethics committee.
Right. And
either the physician, the nurse, the social worker, or a member of the family can, in fact, call for that. They're multidisciplinary committees. People on the committees are trained. I've served on our hospital committees and nursing home committees for decades. And it, in fact, becomes an elder mediation, where the parties are informed of the different options, but a decision is not rammed down their throat.
Who sits on a bioethics committee at most hospitals?
Most hospitals, they will invite the treating physician for the patient, the family members. Then you will often have the social worker. We usually have, I'm an attorney, we usually will have an attorney, you usually have a clergy person, and most hospital bioethics committee, not necessarily, you don't call the whole committee for a consultation,
right,
but the committees usually have what they call a community member or two, which are just interested people who have had an experience in their lives that they want to give back in some way. And typically, when you're asking for a consultation, you will have arguably 4 people in the room plus the family. You don't want it to be too large.
Okay. In your experience, how do most people feel once they've gone through the process and they've created the advance directive?
Generally speaking, it's very cathartic. One of the things I can share with you, I'm going to share with you in the last minute or so, some resources. Okay. I keep saying that one of the things I'm most partial to are the hospital advance directive forms. But there's a kinder, gentler form out there.
Okay.
And it's called the 5 wishes.
Oh, okay.
It's easy to Google.
Yeah.
Anyone can find it.
Okay.
It has, in fact, it was started in Florida over 20 years ago, and it was distributed widely through the auspices of the Robert Wood Johnson Foundation.
Oh, okay.
It's a kinder, gentler advance directive.
Okay.
So if someone wants to put their toe into it, that's where I recommend they start.
Okay.
Now, if POLST spoke to them, if there's someone in their family that they say, boy, this is really what they need,
Right.
there is a fabulous 3-minute YouTube
Okay.
called Max's Story.
Oh,
And it's
okay.
called Max's Story, An Advance Directive is Not Enough.
Okay.
And as most of these things, they start in Oregon. And this was from the West Coast. And they're much more sophisticated about their registries and everything there.
Right.
But it's a wonderful 3-minute little video clip. And I would recommend anyone who thinks that POLST may be appropriate for a friend or a family member, that would be a wonderful place to start.
Great resources. Well, I will definitely put up links on the Pro Se Nation website.
The point that I'd love to leave with the audience is that these documents are tools intended to engage and have the communication. But think of them as opportunities. It's an opportunity to, when you can no longer speak for yourself, that you have in fact been able to speak ahead of time.
Right.
And it's an opportunity for you to control, for you to be a participant. And equally as important, it gives your family members the comfort of knowing when they're faced with the decision that you have in fact guided them.
Yes.
And it is really a blessing to the people that you leave behind to give them that kind of direction.
Yes. Thank you so much.
My
and
pleasure.
thank you so much for the great work you're doing.
Thank you.
This is really important work.
It's my pleasure to share it with you and your audience.
Thank you. And thank you so much again for joining us for this edition of Pro Se Nation. If you have any ideas for future topics or you'd like to be a guest on the show, please contact me on the prosenation.org website. Thanks so much, and I'll see you in the future.